Okay, Mr. Gladden.
Good afternoon. May it please the court? My name is Richard Gladden. I'm here representing the three plaintiffs in this case. This appeal is from a summary judgment granted by the district court. The appellants have raised essentially two issues on this appeal, one dealing with limitations. The second issue deals with whether punitive consequences must follow the breach of a plea bargain agreement by the state of Texas in order for the terms of the plea bargain agreement to be enforceable. I believe this case is primarily controlled by the Fifth Circuit's decision in Stewart versus Mississippi Transportation Commission, which incidentally is a case that was unanimous on the issue we bring on this appeal. I believe Judge Haynes, who had recently begun serving on this court, wrote a concurring and dissenting opinion, but on the issue of limitations that we deal with in this case, she joined the majority opinion.
Your limitations argument, as I understand it, correct me if I'm wrong, all rises or falls on the continuing violation doctrine.
That would be one way of putting it, but actually there's two issues within that limitations. There's not many cases out there where someone has had their constitutional rights violated or allegedly violated within a limitations period, and an issue arises on appeal that the other side is arguing the statute of limitations bars the case even if the action for the subsequent violation accrued during limitations. In the Stewart case, there is a sentence that says, obviously, for a violation occurring during the limitations period, there is no bar under the statute of limitations.
Now, on that, are you relying on the requirement of periodic re-registration?
I don't think we have to win. In this case, it's undisputed. There's a stipulation entered by the state of Texas with the appellants that they acknowledge that they, on an annual basis and continuously through this year and going, I guess, for the remainder of my clients' lives, will be breaching the plea bargain agreement by imposing disabilities and the other requirements that come under Chapter 62 of the Texas Code of Criminal Procedure, which is the registration.
Did they say it was a breach?
They haven't acknowledged it's a breach.
Okay, so you said they stipulated that it was a breach.
Okay.
That's not my memory.
Okay, I'm sorry if I misspoke. They stipulated that they've been applying this allegedly unconstitutional breach and continue to do so and intend to do so into the future. Their argument is, and I think the best way of making an analogy is if the state of Texas had a policy to search people's homes, without probable cause or a warrant, and they did so under the policy in 1997, and the aggrieved individual did not sue within 2 years, under the state's argument, the state of Texas forever after, for the remainder of that person's life, could search their homes without probable cause or a warrant. And so basically they're using the continuing violation doctrine as a sword rather than the way it would work as a shield that would shield a governmental entity from compensatory damages going back to conduct occurring outside the limitations. So we've got basically two grounds. The first ground is there's no dispute that they applied this policy and continue to and will in the future with regard to conduct that would violate the plea. The pleas in each case said, at least as...
So why didn't they bring this up sooner? If this is such a problem for them, why did they not bring it up sooner?
Well, of course, until they'd completed the length of their community supervision, they would not have had, it would not have been ripe yet. As far as what happened since 1997, I haven't discussed it a whole lot with them, but I would speculate that it's kind of hard to find a civil rights lawyer that will take a case on a contingent basis and file a civil rights 1983 case. We certainly, when they contacted me, moved as quickly as was reasonable under the circumstances. But I don't think if someone searches your house without a warrant, it doesn't really make a whole lot of difference for limitations purposes that they did the same thing in 1997.
But the breach here, as I understand it, in your view, is the passing of the legislation.
No.
I mean...
No, we've never said that.
Okay. Then what's the problem?
They're breaching the plea by requiring my clients to comply with Chapter 62.
But that's because there is a statute, and employees of the state of Texas have to follow Texas law. So that's the problem, right? The Texas law.
In Brown versus Board of Education, I don't think someone said, since the state has segregated African American students in public schools since 1879, you should have sued before the kid got into the third grade. But that's basically the way this theory of the state of Texas would operate. We're asking for equitable relief, not compensatory damages, which is usually what's in dispute when a continuing violation doctrine is raised for purposes of collecting damages outside the limitations period. This is just an equitable declaration with prospective equitable relief saying you have breached the plea bargain, and under Santabello, we're entitled, and we're not asking to withdraw pleas. We're asking for the state of Texas to live up to its word. And let me tell you, if everybody finds out as a result of this case that the state of Texas never has to live up to its word in plea bargains, 95% of cases under state law, and probably higher in the federal courts, are cases that are disposed of through pleas.
Okay, but the problem of that is that they're disputing that they're not living up to their plea.
They're saying that they never agreed
Right.
Not to break the deal.
No, they're saying they never agreed that there wouldn't be some statute that would require him to have to register as a sex offender.
Okay. And in Santabello, the first prosecutor never promised the second prosecutor would live up to the deal the first prosecutor made. But the second prosecutor asked for the maximum sentence, which did breach the agreement that was made between the first prosecutor and Santabello.
Hey, let me ask you this. Has anybody on the other side raised any sovereign immunity issues in this case?
No.
Okay. But they have argued that you should have...
Excuse me. I believe maybe early on, I think they had raised an 11th Amendment claim, and the district court disposed of that adversely to the defendants because we're seeking equitable relief, not compensatory damages. And because it's prospective, the 11th Amendment would not bar the relief requesting.
Okay, so that was raised in the district court?
I get cases mixed up, but I believe that might have been raised in an original motion to dismiss, but I don't think it was. I'm not sure.
They didn't raise it in their brief on appeal. Do we need to address it if they didn't raise it?
I don't think you can because they didn't file a cross appeal. The district court did address whether defendants acting in an official capacity stand in the shoes of the state for purposes of equitable relief. And the court did reject that argument. It's an argument they raised in every case I have with them.
So one thing they did raise is you should have sued somebody different, whether it's the prosecutor or somebody like that.
Right,
so how do you respond to that?
Well, the prosecutor didn't breach the agreement. The prosecutor was acting as an agent of the state of Texas, but that does not mean the Texas Department of Public Safety, which is defined as a state agency, wasn't acting as an agent of the state of Texas. And we're saying it's the Department of Public Safety that's breaching the agreement as an agent of, ultimately, the state of Texas. So it's the breaches between the state of Texas and my clients. Did I answer your question? Yeah.
I think you've given me
Okay. Well, I wasn't sure whether... Now, with regard to the Santabello issue, what the district court ruled in this case is the Santabello claims under the 14th Amendment are not substantive, which there are other courts of appeals have said it is a fundamental fairness, substantive due process right. They're saying that because they have so many employees, they shouldn't be held responsible. That is, the state of Texas has so many employees. And most significantly, what the district court ruled in this case is like the ex post facto clause, under contract analogies, someone would have to show a criminally punitive consequence arising from the state's breach of the plea bargain agreement. I gave you examples that would kind of end a lot of plea bargains, because currently, in both in the federal and state system, you have agreements not to prosecute a family member in exchange for a plea. Were that broken, it wouldn't be criminally punitive. Don't pursue me for civil forfeiture, and I'll plead guilty. A breach of that agreement would not be criminally punitive. There's all kinds of plea bargain agreements, the consequences of which would not result in criminal punishment. It also, this interpretation of Santabello would render the ex post facto clause meaningless, or the Santabello decision meaningless, because it would confine relief under Santabello to conduct that would already be prohibited in the ex post facto clause. And so we think Santabello stands for something else. Of course, one thing I would note in Santabello is the Supreme Court said that the fact in that case, the trial judge had said, the breach did not influence me in sentencing this defendant. And in Santabello, the U.S. Supreme Court said there needs to be no showing of harm. That is, it makes no difference whether the trial judge was influenced by the breach or not. It's an automatic thing. If the term that's violated would have been material to induce someone to consider and decide to waive the right to a criminal trial, there has to be relief. In this case, we're asking for the state of Texas to live up to its word. And Mr. Jones's plea paperwork, and I set it out in the brief, they flat out said, your duty to register as a sex offender will expire upon you successfully completing your deferred adjudication. One thing that may not be clear from the briefing on this is that Texas also had a contemporaneous in all three defendants' cases, or plaintiffs' cases, that under the deferred statute, the conclusion of deferred entitles a person to have all legal disabilities removed. And I cite some Texas, the Court of Criminal Appeals interpretation of that phrase as being intended, legislatively intended to be broad, and they granted someone relief, not in this context, but in the possession of a handgun. As it, for a while in Texas, if you got deferred for possession of a handgun or another felony that would have barred you from possessing a handgun, if you lived up to your part of the deal, the Court of Criminal Appeals says the state of Texas has to live up to that, because that was provided under statutory law at the time of those kind of pleas. And so what you've got is a state government saying, we can breach plea bargain agreements at will. And it's kind of shocking, and I think a large part of my practice is criminal defense. I'm not going to be taking any plea bargain agreements, no matter how much they insist they're going to live up to it, because they might, 20 years later, come back and decide they don't like that deal, and they're going to breach it. And there's no question that had my clients known that they were giving up their rights to trial, and that basis could be used to make them register as sex offenders for life, that was something that would have been pretty material to somebody deciding whether to give up their right to trial. Donnie Miller had gotten a mistrial, and he decided to plea after a mistrial, only, according to him, because he was assured that this would all be behind him after he successfully completed deferred, and that any duty to register would expire, as the law said at the time, at the successful completion of his deferred. Unless I see my time is up, I'll reserve the remainder of my time for rebuttal.
Yes, you've saved time for rebuttal. Thank you, Mr. Gladden.
Thank you.
Okay, Ms. Pettit, or if I'm mispronouncing it, please correct me.
Pettit is correct. Thank you, Judge Smith, and may it please the court. I believe we've lost this again. Okay. So in this case, plaintiffs seek to use artful pleading to avoid this court's repeated holdings that Texas may constitutionally apply its lifetime registration requirements to sex offenders whose crimes were adjudicated before the law's passage. But as we've explained in our briefs, they seek a form of remedy that is unavailable based on a substantive due process theory that doesn't exist and that needed to be litigated, if at all, 20 years ago in state court.
Now, if we rule in your favor, are we ruling that you all never have to follow your plea deals?
Not at all, Your Honor.
Okay, explain the difference then between us affirming in this case and us holding that the state of Texas never has to follow its plea deals.
Certainly, Your Honor. So I would point the court to the language in Santabello that explains the scope of the right that Mr. Gladden purports to invoke here, which is that that it is a specific remedy designed to approach what the court called an unfortunate lapse in orderly prosecutorial procedures. It is tied to the specific promises that the prosecutor made and goes no further. And to respond to your question, Judge Haynes, the promises here, it's about what promises were made and what promises need to be kept. And in Mr. Gladden's discussion, I did not hear at any point him say that the prosecutors made any sort of promise about the ongoing obligation to register.
What about the Jones issue where it says that you won't have to register anymore once you're done?
So, Your Honor, the plea bargain agreements themselves are not actually in the record. The notice that is reflected in the briefing is actually just that. It's a notice from the court about the ongoing obligation that is given to all people who have pled guilty so that they know this obligation exists and they don't inadvertently become subject to a felony prosecution for failure to register. It is not an affirmative promise that obligation will not change. But that's really the difference here. And I think the way to sort of focus the court and maybe make it clear what the difference that Your Honor asked before is to look at the Foley case out of Tennessee from 2020 that the plaintiffs relied on in their opening brief. In that case, the criminal defendants specifically negotiated a promise from the prosecutors that they would not have to be registered. The state acknowledged that promise in the record, and the Tennessee state courts enforced that promise and significantly enforced it on a writ of habeas corpus, not as here on a civil claim. So that highlights a couple of the different problems in this case, namely that there's no evidence in the record. And again, Mr. Gladden didn't suggest here that the prosecutors made any promises. Instead, they are simply saying that the law as it existed was incorporated into the plea bargain. The Ninth Circuit in ACLU of Nevada against Masto faced a similar argument, and they noted that yes, that's true, but also incorporated into the agreement is the notion that the legislature can act under its traditional police powers to protect the public. That is precisely what happened here in 1997. And in that case, in Masto, the Ninth Circuit said there would have been a difference if the prosecutors had promised that they would not be, that the plaintiffs in that case would not have to register, but they didn't. And so the claim was governed by the ex post facto clause and not by Santabello. That is what this court should hold here, that this claim is governed by the ex post facto clause, and the plaintiffs here have waived any claim that the Texas law is problematic, in part because this court has repeatedly held that it is not. So that's why their claim fails on the merits. Their claim also fails because it shouldn't be in this court at all. Again, as I mentioned in the Foley case, that was pursued in a state habeas petition. And the reason why is Santabello itself suggested that the remedy at issue is not, as the plaintiffs suggest here, that they would be removed from the register. That is also what Foley concluded. Instead, what Santabello said is that you go back to the trial court and you either get a chance to replead or you get resentenced. Either of those requires reversing the conviction that the plaintiffs are currently under, and that is precisely what this court cannot do in Heck.
Have you made a a sovereign immunity claim in this case?
No, Your Honor. And the court can address sovereign immunity under Calderon against Ashmith, even on appeal. However, I don't think that it's necessary in this case or particularly appropriate because the district court made a finding that these were appropriate defendants at least for ex parte Young purposes, in that they had an ongoing duty to administer the registration system, which under this court's case in KP against LeBlanc is probably a correct conclusion. And until that decision is addressed on banc review, we do not ask the court to find alternatively here. So I've explained why this is the wrong claim in the wrong court. It's also at the wrong time. And so returning to the statute of limitations issue that Judge Haynes was asking Mr. Gladden about to begin with, you have it exactly right. The breach in this case occurred in 1997 when the legislature changed the law. They nonetheless claim that there's this continuing violation, or as they put it today, a new violation every time they have to register or every time the registration goes through the DPS. That's not how accrual in 1983 works. Instead, under Wallace against Cato, the United States Supreme Court said that to identify when cases accrue under 1983, you have to determine the injury with particularity so that you can analogize it to the closest related state law claim, typically a state law tort. Here, the plaintiffs have asked you to analogize to a state law breach of contract. It doesn't really matter. Either way, you get to the same point, that their claims expired in 2000. Specifically, a breach of contract claim accrues at the time that performance was due and not performed, or in the case of a repudiation, when the plaintiff learns that the contract would not be performed. Under fraudulent inducement, which is the closest related state law tort, the claim actually accrues at the time of contract, but it's subject to a discovery rule when the alleged fraud they would have known that they would have had that claim. Here it's the same date. In the breach of the contract, namely the learning that the state would not keep its purported promise that they would stop having to register at the time their deferred adjudication ran. And when they learned about that they had been somehow misled by the state of the law at the time was when the law passed in 1997. It is not, as the plaintiff suggests, a continued breach for that process to continue to be updated. And
do they have the ability to bring a habeas now, or would you all claim limitations on that as well?
Your Honor, that would be a decision for the state court to make. I'm not aware of any facts that would have prevented them from bringing habeas earlier, which may make it difficult, but it's hard to say that it's impossible. And as this court held, and I believe it was McAllister, that the availability of habeas is actually not the determining factor under Heck, because under Heck, the question is really about the scope of the 1983 release and the importance of protecting the comity interests and federalism.
Yeah, I was just addressing your point, which is this is how you deal with a violation. It's by filing a habeas. So I was asking you, if we ended up concluding that, is it too late for them to bring a habeas?
Probably. They could probably in this particular instance, but that doesn't mean that there's not a possibility of relief in the future. Because as this court recognized in Dunn McCampbell, and as Your Honor recently held in Texas against Reddick, even if you fail to bring a facial challenge within the statute of limitations from when the statute was passed, it can still be challenged later if the statute is applied to a particular defendant. But as Your Honor recognized in Reddick, ministerial actions of this type are not applications within that particular sense. So here, what is happening is simply that they are confirming on an annual basis that the information that's currently in the register is active, and that's not an actual application in the sense that you see in Foley, for example, where they raised it as a defense to a prosecution or to an indictment for failure to register. At that point, there will be a live question, and for the reasons I've already explained, that defense would not be valid, but it would not be time barred. So, as I've explained, they're seeking the wrong remedy in the wrong court at the wrong time. And for those reasons, we ask that you affirm. And unless the panel has any other questions, I'll take my seat.
Thank you, Ms. Pettit. Mr. Gladden, you've saved time for rebuttal.
First of all, I'm not going to spend very much time on it, but Heck says you cannot bring an action under 1983 if the relief you're seeking would either invalidate your conviction, which is not the case in this situation, or affect the duration of your sentence, which is not the case in this situation. And I think Heck is a red herring that has, as the district court, actually, I quote in my reply brief, was totally unimpressed with that. And I don't think it's appropriate since the state has not shown that that was a basis for the district court's decision, and they haven't filed a cross appeal. I don't
understand that argument, because can't we affirm a cross appeal is needed if they wanted more, if they wanted, say, their attorney's fees or something out of this, and didn't ask for it. But we can affirm on any ground that's supported by the record, right?
No.
Okay. Why not?
The case I cite in my brief, in my reply brief, I think it was probably about a year ago, a panel of this court reverted back to the original intent that applied to the scope of appellate review, that the district court in a trial without a jury has an obligation to reduce to writing or to state on the record the grounds for his or her decision in the trial court. And that limits the scope of appellate review. So unlike Texas state courts, where a judgment can be affirmed on any basis supported by the record, that is no longer the status of decision along with
Well, we have hundreds of cases that say that, so I'm not really
That's right, and hundreds of cases have followed the original rule of this circuit that was readopted.
Because a subsequent case cannot overrule a prior case in our court.
Exactly. And I'm sorry, I don't have the brief handy, but it is cited in my reply brief, I think probably in the first couple of pages. And so the district court didn't enter any findings saying that it was ruling on the basis of the Heck decision. In fact, its statement that I've quoted from the record shows it was very unimpressed with the Heck argument. Now, as far as the rest, there's no doubt that someone can be induced to waive the rights to a trial based upon the reliance on statutory law. Under the Lex Loci doctrine, which goes back to even before the colonies in this country, a agreement will have implied or has implied the law of the locality and in a place at the time of an agreement. This is a federal question. It's not the city of Fort Worth or the city of Austin's locale. It's a federal determination, and under the law that did apply in this case, although it was Texas law, those terms were implied into the agreement between my clients and the state. The state says that we haven't shown any evidence that anybody with the state of Texas made a promise. Well, the prosecutor signed Mr. Miller's plea papers, and the judge signed Mr. Miller's plea papers, and there's a bold paragraph in there saying exactly what you brought up. Your duty to register as a sex offender will expire if you take this deal and give up your right to a trial after you've already got one mistrial. And that induces somebody, and that's what the statute said at the time. And with regard to Mr. Hearn, he has the benefit of relief under the deferred adjudication statute because he was told by his lawyer, by the court, by his understanding of the correct application of the law at the time, that all disabilities would be removed if he accepted the deal, gave up to his right to trial, and lived up to his part of the bargain. And he did. And the state of Texas says we can change the deal anytime we want to. And that's going to be a problem if you're expecting criminal defendants who have a choice to go to trial and give up valuable constitutional rights only to have the state of Texas walk into this courtroom saying, we can break deals anytime we want to. So, unless someone has additional questions, I would return the remainder of my time to the court.
Thank you, Mr. Gladden.
Thank you.
The case is under submission.